Hey guys! So in this video, I'll be discussing Section 7, 8, and 10 of the Bill of Rights or Article 3 of the 1987 Constitution. You see, we already skipped Section 9 because the power of eminent domain was already discussed in another video, and it's the taking of private property shall not be made without just compensation. And also, I'm sorry if you're gonna hear some background noises because our neighbor is building their house or their building or whatever, and we have a construction going on. I've been looking for a time to for them not to be this noisy, but I haven't found a time. I mean, until nighttime they're constructing, so I'd rather do this instead with them on the background. So please bear with my video. Anyway, the source for this video will still be from the books of Bernas and De Leon and also from the reviewer of Clarence. So let's begin. Section 7 is the right to information. So the right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded to the citizen, subject to such limitations as may be provided by law. So in Article 2, or the Declaration of Principles and State Policies, Section 28 says that subject to reasonable conditions prescribed by law, the state adopts and implements a policy of full public disclosure of all its transactions involving public interest. So, what is the scope of Section 7? So, the right to information includes the right of access to official records, documents, and papers pertaining to official acts, transactions, and decisions, government research data used as basis for policy development, and any other information on matters which is of public concern. So, the rationale for this rule is that access to public records is predicated on the right of the people to acquire information on matters of public concern, since undoubtedly, in a democracy, the public has a legitimate interest in matters of social and political significance. The incorporation of this right in the Constitution is a recognition of the fundamental role of free exchange of information in a democracy. So there can be no realistic perception by the public of the nation's problems, nor a meaningful democratic decision making if they are denied access to information of general interest. So, information is needed to enable the members of the society to cope with the exigencies of the times. So, as has been aptly observed, maintaining the flow of such information depends on protection for both its acquisition and its dissemination, since if either process is interrupted, the flow inevitably ceases. So the objective is to promote transparency in policymaking and in operations of the government, as well as provide the people sufficient information to exercise effectively other constitutional rights. They are also essential to hold public officials at all times accountable for to the people. So, for unless citizens have the proper information, they cannot hold public officials accountable for anything. Go. So we go now to who can invoke this right. So any citizen has standing to invoke this right. When the question is one of public right and the object of the mandamus is to procure the enforcement of a public duty, the people are regarded as the real party in interest, and the relator at those instigation the proceedings are instituted need not show that he has any legal or special interest in the result, it being sufficient to show that he is a citizen and has such interested in the execution of the laws. So, what is the meaning of matters of public concern? In determining whether or not a particular information is of public concern, there is no rigid test which can be applied. Public concern is like public interest. It's a term that eludes exact definition. Both terms embrace a broad spectrum of subjects which the public may want to know, either because these directly affect their lives or naturally arouse the interest of an ordinary citizen. In the final analysis, it is for the courts to determine in a case by case basis whether the matter at issue is of interest or of importance as it relates to or affects the public. So, is this self executory? So, yes. right to information on matters of public concern are self-executing. They supply the rules by means of which the right to information may be enjoyed by guaranteeing the right and mandating the duty to afford access to sources of information. Hence, the fundamental right therein recognized may be asserted by the people upon the ratification of the Constitution without need for any auxiliary act of the legislature. So, what is the procedural remedy to invoke this right? So, the aggrieved citizen may file an action for mandamus. So, the burden of proof that it is not matters of public concern or it falls under one of the exemptions that will be discussed later is on the government agency concerned. So, in case of denial of access, the government agency has the burden of showing that the information requested is not of public concern, or if it is for public concern, that the same has been exempted by law from the operation of the guarantee. So, to safeguard the constitutional right, every denial of access by the government agency concerned is subject to review by the courts, and in proper cases, access may be compelled by a writ of mandamus. So may the right to information be regulated? Of course, yes. Obviously, the government agency may administratively regulate access and the manner of the exercise of the right to preserve the information sought. However, once the right is deemed available, only regulation is allowed, not prohibition. Government agencies are without discretion in refusing the disclosure of or access to information of public concern. This is not to lose sight of the reasonable regulations which may be imposed by said agencies in custody of public records on the manner in which the right to information may be exercised by the public. Regulations which the Register of Deeds may promulgate are confined to prescribing the manners and hours of examination to the end that first, damage or loss of the records may be avoided. Second, undue interference with the duties of the custodian of the books and documents and other employees may be prevented. And third, the right of the persons entitled to make inspection may be ensured. So while the manner may be subject to reasonable regulation by the government, the duty to disclose information of public concern and to afford access to public records cannot be discretionary on the part of the said agencies. Certainly, its performance cannot be made contingent upon the discretion of such agencies. Otherwise, the enjoyment of the constitutional right may be rendered nugatory by the whimsical exercise of the agency. So, can government agencies inquire as to the purpose of why a citizen is interested in a certain information? So, the answer here is no. They cannot concern themselves with the motives, reasons, and objects of the person seeking access to the record. So, wala silang pakialam kung ano yung reason mo for accessing the records, except when there is a clear purpose of the examination that is found to be unlawful, or it's because of idle curiosity. It is not the prerogative to see that the information which the records contain is not flaunted before public gaze, or that scandal is not made out of it. So if it be wrong to publish the contents of the records, it is the legislature and not the officials having custody thereof, which is called upon to devise a remedy. So, what can be provided for by the legislature are reasonable conditions and limitations upon the access to be afforded, which must, of necessity, be consistent with the declared state policy of full public disclosure, like I mentioned a while ago, of all transactions involving public interest. So we go now to the test. What is the test for validity of a law which curtails the right to information? So in the book of Bernas, it says that the standards that have been developed for the regulation of speech and press and of assembly and petition and of association are applicable to the right of access to information. So this refers to the clear and present danger test, which we have been discussing in our constitutional law videos. So some of the jurisprudence in Section 7, wherein information which is required to be disclosed as it covered under the right, like in the case of what's that? Like in the case of Chavez versus PEA. So information, for instance, on ongoing evaluation or review of bids or proposals being undertaken by the bidding or review committee is not immediately accessible under the right to information. While the evaluation or review is still ongoing, there are no official acts, transactions, or decisions on the bids or proposals. So also in the case of Hilado et El Hilado versus Judge in 2006. Decisions and opinions of a court are matters of public concern or interest. Access to courts records may be permitted at the discretion and subject to the supervisory and protective powers of the court, after considering the actual use or purpose for which the request for access is based on the obvious prejudice to any of the parties. And also in the case of Legazpi versus Civil Service Commission, it says that civil service eligibilities of members of the civil service should also be disclosed. So also in the case of Antolin versus Dumondon, national board examinations such as the CPA board exams are matters of public concern. So the populace in general and the examinees in particular would understandably be interested in the fair and competent administration of these exams in order to ensure that only those qualified are admitted into the accounting profession. So what are the information that are not covered under the right and disclosure may not be compelled? So what are those? First is we have national security matters. So this doesn't count as under section 7. Also, criminal matters or classified law enforcement matters, such as those relating to the apprehension, the prosecution, and the detention of criminals, which courts may not inquire into prior to such arrest, detention, and prosecution. Otherwise, efforts at effective law enforcement would be seriously jeopardized. And also, pleadings and other documents filed by parties to a case, so you can't really access pleadings, need not be matters of public concern or interest. They are filed for the purpose of establishing the basis upon which the court may issue an order or a judgment affecting their rights and interests. Fourth is diplomatic correspondence. Fifth is closed door cabinet meetings. Sixth is executive sessions of either House and Congress. Seventh is internal deliberations of the Supreme Court. Eight is trade secrets. Nine is banking deposits and transactions. 10 is informer's privilege. 11 is presidential communications privilege. 12 is deliberative process privilege. And lastly, information, however, on ongoing evaluation or review of bids or proposals, like the case a while ago I mentioned, being undertaken by the bidding or review committee is not immediately accessible under the right to information. While the evaluation or review is still ongoing, there are no official acts, transactions, or decisions on the bids or proposals. However, once the committee makes its official recommendation, there arises a definite proposition on the part of the government. From this moment, the public's right to information attaches, and any citizen can access all the non-proprietary information leading to such definite proposition. Okay. So we go now to Section 8, or freedom of association. So the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. So in the book of Bernas, it says that all this means that the right to form associations shall not be impaired except through a valid exercise of police power. It is therefore an aspect of the general right of liberty. More specifically, it is an aspect of freedom of contract. And insofar as associations may have for their object the advancements of beliefs and ideas, freedom of association is an aspect of freedom of expression and of belief. So what is the scope of Section 8? So we have persons both in public and private sectors. They may form unions, associations, societies. And we also have persons that may not be compelled to join unions, associations, and societies. So the guarantee says that it also covers the right not to join any association. So how about government employees? Government employees have the right to form unions. This is covered under Section 8. So the right to strike may be limited by law. The Supreme Court has definitively ruled that employees of the Social Security system and public school teachers do not have a constitutional right to strike, but the current ban on them against strikes is statutory and may be lifted by statute. So this was said in the case of SSS versus the Court of Appeals, Manila Public School Teachers Association versus Secretary of Education. So what is the test for validity of a law which curtails the right to association? So it depends on the purpose of the association. If the purpose is a manifestation of the freedom of speech, then the standards of such right will apply. We also have the purpose test. So in the case of De Honge versus Oregon, ideally the test should be the purpose of the assembly regardless of its backers. And also the auspicious test, um, it says in the ruling in Evangelista versus Earnshaw that the ruling has not been abrogated. Here, the Manila mayor revoked the permits he already granted because the group was found by the fiscal to be an illegal association. So, do all societies and associations enjoy the same constitutional protection? So, the answer is no. The Constitution recognizes a hierarchy of values. So, in the hierarchy of civil liberties, it said in the case of PBM, or Philippine Blooming Mills Employees Organization versus PBM Corporation Incorporated, that in the hierarchy of civil liberties, the right of free expression and of assembly occupy a preferred position, as they are essential to the preservation and vitality of our civil and political institutions. The superiority of these freedoms over property rights is underscored by the fact that a mere reasonable or rational relation between the means employed by the law and its object or purpose, that the law is neither arbitrary nor discriminatory nor oppressive, would suffice to validate a law which restricts or impairs property rights. During the meeting here in Philippine Bloomingdale's, the planned demonstration was confirmed by the union, and they were illegally dismissed because the corporation said that it was under their collective bargaining agreement that they would not form strikes. But then the purpose of the strike was against, I think, the Pasig police officers. They had a problem with that, and they really specifically said that the strike wasn't against the company. So it was a case that they were actually illegally dismissed, and their right is already covered under section 8, also their right to association. So, permissible limitation on student demonstration within school premises was said in the case of Malabanan versus Ramendo. So, students enjoy the rights of free speech and peaceable assembly within the school. So, school authorities may require that a permit be secured before any assembly may be held within the school. So, school officials cannot deny a permit except when there is a showing of a clear and present danger of a substantive evil that it has a right to prevent. So the permit granted may impose conditions as the time and place of the assembly in order to avoid the disruption of normal school activities. So the students responsible may be punished for violating the terms of the permit if such violation results in the commission of acts that would constitute a substantive evil. So the penalty imposed must be proportionate to the offense committed. So the degree of protection an association enjoy depends on the position which the association's objective or activity occupies in the constitutional hierarchy of values. Thus, for instance, where the object of an association is the advancement of a common political belief such as racial equality, any law that either has the effect of limiting membership in such association or blunting its effectivity must satisfy the more stringent standards for allowable limitation of expression and belief. So there are associations such as the illegal associations and assemblies under the revised penal code. There are also under labor code, it says that managerial and confidential employees cannot form unions, and supervisory employees may form unions but not with the rank and file employees. So lawyers are also compelled to join the integrated bar of the Philippines as a prerequisite to the practice of law, and if they should continuously pay their IBP dues, and they should always be part of the IBP even if they're not practicing. So there's also subversive organizations. So some of the jurisprudence on section 8 rather is there's this case. So Bel Air Village versus Association versus Janicio. So a land buyer buys a lot with an annotated lion, and that the lot owner becomes an automatic member of the homeowners association. So such annotation does not violate the right to join freely or not to join association. So the fact that the obligation is annotated in the title does not make it a government act forcing one to join an association. It says in that case. So rather, the buyer freely buys the lot, knowing that the purchase will entail the obligation to join the homeowners association. And it also said in the case of United Pepsi Cola Supervisory Union versus Laguesma that the first sentence of Article 245 of the Labor Code provides that managerial employees are not eligible to join, assist, or form any labor organization. So such provision is valid because the right under Article 3, Section 8 is subject to the condition that its exercise should be for purposes not contrary to law. So the rationale here is because if the managerial employees would belong to or be affiliated with the union, the latter might not be assured of their loyalty to the union in view of the evident conflict of interest. So this was also discussed in one of my videos in labor law. So the union can also become a company dominated with the presence of managerial employees in the union membership. And lastly, in the case of Osefia versus Comelec, so Batas Bilang 222 prohibits any candidate in the barangay election of May 17, 1982 from representing or allowing himself to be represented as a candidate of any political party and prohibits a political party, political group, political committee from giving aid or support directly or indirectly, material or otherwise, favorable or against a barangay candidate's campaign for election. So this was said to be valid. The right is not absolute, and the prohibition found in the law is couched in a very narrow term. So the law is intended to make a clear and imminent danger of the debilitation of the electoral process and also the danger of disenabling barangay officials from adequately performing their function as agents of a neutral community. So we go now to Section 10. So Section 10 is a non-impairment clause. So it's no law impairing the obligation of contracts shall be passed. So here, the purpose is to safeguard the integrity of valid contractual agreements against unwarranted interference by the state. So the general rule is that contracts should be respected by the legislature and not be tampered with by the subsequent laws that will change the intention of the parties or modify their rights and obligations. The will of the parties to the contract must prevail. So contracts affected here are legal, executed, and executory contracts, which must be valid. So the limitations include that a contract valid at the time of its execution may be legally modified or even completely invalidated by a subsequent law. Strict construction, so it includes charters, franchises, and licenses granted by the government, are strictly construed against the grantees. If a law is a proper exercise of the police power, it will prevail over the contract. This is because public welfare is superior to private rights. And to each contract are read the provisions of existing law and always a reservation to the police power as long as the agreement deals with the matter of affecting the public welfare. Eminent domain and taxation may also validly limit the impairment clause. So, what are the exceptions? A law may impair a contract if it is an exercise of if a valid exercise of police power. So, when is there an impairment of contract? So, a valid exercise of police power is superior to the obligation of contracts. So, not all existing laws read into contracts in order to fix obligations as between the parties, but the reservation of essential attributes to the sovereign power is also read into contracts as postulate of the legal order. So again, when what is so again we go to the question I said a while ago. When is there an impairment of a contract? So the requisites: a law impairs a contract when one, it changes the contract between parties by either changing the terms of a legal contract between the parties, either in time or mode of performance, imposing new conditions or dispenses with those expressed, authorizing for its satisfaction something different from that provided in its term, um, authorizing for its satisfaction something different, changing the intention of the parties. And number two, the impairment must involve substantial rights and not mere procedural remedies. So mere change in procedural remedies, which does not diminish substantive rights or increase substantive nature of the obligations, does not violate the guarantee. This is because the parties have no vested right in particular remedies or modes of procedure. Legislature may change existing remedies or modes of procedure without impairing the obligations of contracts, provided any efficacious remedy remains for enforcement. So it is competent for the state to change the form of remedy or to modify it otherwise as they may see fit, provided no substantial right secured by the contract is thereby impaired. So every case must be determined upon its own circumstances. So the general doctrine of this court on this subject may be thus stated that in modes of proceeding and forms to enforce the contract, the legislature has the control and may enlarge, limit, or alter them, provided it does not deny a remedy or so embarrass it with conditions or restrictions as seriously to impair the value of the right. But while the procedural remedies to enforce contractual obligations may be altered, it cannot be changed in such a way as to amount to a deprivation of substantial rights, of course. So the state may postpone the enforcement of the obligation, but cannot destroy it by making the remedy futile. The true test, therefore, of the constitutionality of a moratorium statute lies in the determination of the period of the suspension of the remedy. It is required that such suspension be definite and reasonable. Otherwise, it would be violative of the Constitution. And third, the third requisite is that the law must change the relationship between the parties to the contract and not between the parties and non-parties. So imposing additional taxes does not change the relationship of the parties with each other, but rather it changes the relationship with the government. So a rehabilitation plan approved by statute which merely suspends the actions for claims does not violate the contract or the impairment clause. So the sovereign right of the government to protect the lives, health, morals, comfort, and general welfare of the people, and is paramount to any rights under contracts between individuals. So the argument is pressed that in the cases we have cited, the obligation of contracts was affected only incidentally. So this argument proceeds upon a misconception. The question is not whether legislative action affects contracts incidentally or directly or indirectly, but whether the legislation is addressed to a legitimate end and the measures taken are reasonable and appropriate to that end. So the means and the ends has to be reasonable and appropriate. So what are the exclusions of Section 10? So the exclusions are license and franchise, marriage contract, and also public office. And we go now to the test. So what is the test of validity of a law which impairs a contract? Since the rights of the parties arising out of a contract are considered property, then the test for substantive due process applies. So there must be a legal purpose, and this is what we call, we already discussed this also in our previous videos, the rational basis test. So the effect, so we go now to the effect of emergency legislation and contracts. So, for example, the pandemic, the Bayanihan Hilason Act, in a national emergency, such as a protracted economic depression, or like what I said, the COVID 19, the police power may be exercised to the impairment. In order to come within the meaning of the constitutional provision, the obligation of the contract must be impaired by some legislative act. So, like I said, they had to pass a law, like the Bayanihan Act. The act need not be by a legislative office, but it should be legislative in nature. Furthermore, the impairment must be substantial. A mere administrative order, though not legislative in nature, may not be considered a cause of impairment within the scope of the constitutional guarantee. The guarantee is also not violated by court decisions. The act of impairment is anything which diminishes the value of the contract. The legislature may, however, change the remedy or may prescribe new modes of procedure. The change does not impair the obligation of contracts so long as another remedy, just as efficacious, is provided for the adequate enforcement of the rights under the contract. So our franchises, like what I said a while ago, the exclusions, are franchises and licenses granted by the government, protected by the non-impairment of contracts clause. So, like I said, since nasa exclusion nga siya, no, they are not considered contracts. It is one of the first principles in the field of administrative law that a license or a permit is not a contract between the sovereignty and the licensee or the permittee, and it's not a property in any constitutional sense, as to which the constitutional prescription against impairment of the obligation of contracts may extend. A license is rather in the nature of a special privilege or a permission of authority to do what is within its terms. So it is not in any way vested, permanent vested permanent or absolute. So a license granted by the state is always revocable as a necessary consequence of its main power to grant the license or permit. The state or its instrumentalities have the correlative power to revoke or recall the same. And this power to revoke can only be restrained by an explicit contract upon good consideration to that effect. So the absence of an expiry date in the license does not make it perpetual, notwithstanding that absence. The license cannot last beyond the life of the basic authority under which it was issued. So this ends our discussion for section 7, 8, and 10. Thank you for listening to my video. I'll be uploading more for constitutional law too, and other videos also for political law. Thank you for listening, and I hope this helped your review.